Can I be fired right before retirement to avoid paying benefits? Imagine this. You've worked faithfully for the same company for 25 or 30 years. You're just months away from qualifying for a pension, retiree health coverage, or full vesting in your 401k. Then, out of nowhere, your employer calls you in and says, "We're letting you go." You can't help but wonder, can they really fire me right before retirement just to avoid paying benefits? It's one of the most painful situations workers face, and it happens more often than you might think. Employers sometimes try to cut costs by getting rid of long-term employees right before key benefits kick in. But the law provides strong protections against this kind of behavior. In this video, we'll explain what the Employee Retirement Income Security Act, ERISA, and the Age Discrimination in Employment Act, ADEA, and say how courts handle these cases, what counts as illegal benefit interference, and what steps workers can take if they're pushed out before retirement. At-will employment versus legal protections. The U.S. is generally an at-will employment country. That means employers can fire workers at any time for almost any reason. But almost is the key word. Employers cannot fire someone for reasons that violate federal law, state law, or contractual promises. So while at-will gives employers broad discretion, they cannot legally fire you for the specific purpose of denying retirement benefits or because of your age. That's where laws like ERISA and the ADEA step in. Example: if a company eliminates a position because of financial struggles, that may be legal. But if evidence shows the firing was to avoid paying a pension, that could be unlawful. ERISA. Section 510. Protecting benefits. The Employee Retirement Income Security Act, ERISA, ANTI, passed in 1974, sets rules for retirement and health benefit plans. Section 510 is critical here. It makes it illegal for an employer to fire, discipline, or discriminate against an employee for the purpose of interfering with benefits under a retirement or health plan. Deny benefits the employee would otherwise earn through continued service. Example: an employee is 2 months away from vesting in a pension. The employer terminates them with no performance issues. If the main reason was to avoid pension liability, that violates Section 510. Courts require proof of intent. That can include emails, comments from supervisors, or suspicious timing, like long service followed by sudden termination right before vesting, the ADEA, and age discrimination. The Age Discrimination in Employment Act, ADEA, protects workers age 40 and older from discrimination. Many cases of pre-retirement termination involve older workers, which means age discrimination claims often overlap with benefit interference claims. If an employer targets older employees to reduce benefit costs, that's age discrimination. Even subtle patterns, like replacing older workers with much younger, cheaper ones, can support an ADEA claim. Retaliation for asserting rights under the ADEA is also prohibited. Example: a 62-year-old employee is fired right before qualifying for retiree health care, while younger employees with less seniority remain. That suggests both benefit interference and age discrimination. What counts as illegal benefit interference courts look for whether the employer's intent was to interfere with benefits. Not every firing near retirement is illegal, but many are. Illegal examples include firing an employee to avoid vesting in a pension or 401k. Terminating right before healthcare benefits would extend into retirement. Laying off older workers selectively while retaining younger, similarly situated employees. Legal examples may include company-wide layoffs for economic reasons applied fairly. Documented performance issues unrelated to benefits. The difference is intent. If the benefit loss looks like the true motive, the firing may be unlawful. Real-world cases. Case 1. In Intermodal Rail. Employees Assen v. Atchison, Topeka and Santa Fe Railway, 1997. The Supreme Court confirmed that ERISA Section 510 prohibits firing employees to interfere with benefit rights. Case 2. A factory worker with 29 years of service was terminated just before vesting. Evidence showed management discussed pension costs. The court ruled it a violation of ERISA. Case 3. In Hazen Paper Coney v. Biggins, 1993, the Supreme Court held that firing to prevent pension vesting is illegal under ERISA, but not automatically age discrimination under the ADEA, though both may apply depending on intent. Case 4. A group of airline employees sued after being replaced shortly before early retirement benefits kicked in. The court found unlawful interference with retirement rights. These cases show that while proof can be tricky, workers win when evidence shows intentional interference. Impact on pensions, 401ks, and health benefits. The stakes are high. Being fired just before retirement can cost workers. Defined benefit pensions. Lifetime monthly payments, sometimes after decades of service. 401k vesting. Employer contributions may be forfeited if vesting isn't complete. Healthcare benefits. Many plans offer retiree coverage after certain service years. Severance packages. Employers may try to avoid paying promised severance by firing for cause right before eligibility. Losing these benefits can mean thousands or even hundreds of thousands of dollars over a lifetime. That's why the law treats intentional interference as serious misconduct. What evidence workers should look for. If you suspect you were fired to avoid benefits, look for timing. Were you close to vesting when terminated? Patterns. Were other long-term or older workers targeted? Comments. Did managers mention benefit costs? Documents. Emails, memos, or HR notes can reveal intent. Performance. Were you suddenly given poor reviews after years of good service? This kind of evidence helps prove unlawful interference or discrimination. What workers can do if you believe you were fired illegally right before retirement. 1. Gather documents. Keep performance reviews, benefit statements, and termination letters. 2. Request plan information. Under ERISA, you have the right to plan documents explaining vesting and benefits. 3. File a complaint. Contact the U.S. Department of Labor or the Equal Employment Opportunity Commission, EEOC. 4. Consider legal action. Workers can sue under ERISA, Section 510, and the ADEA. 5. Watch for retaliation. If you challenge the termination, the employer cannot retaliate further. Example. A long-time worker fired 1 month before pension vesting files with the EEOC. After investigation, the case settles with full pension rights restored. The bigger picture. Firing someone to avoid paying benefits undermines the entire retirement system. Workers spend decades contributing their time and energy, expecting earned benefits at the finish line. The law recognizes that breaking this promise is deeply unfair and illegal. The FLSA protects wages and overtime. The ADEA shields older workers from bias. ERISA, Section 510, specifically blocks employers from cutting off benefits by firing loyal employees at the last minute. Together, these laws ensure that retirement rights can't just be erased by a pink slip. So, can your employer fire you right before retirement to avoid paying benefits? Under U.S. law, the answer is no, at least not legally. The ERISA Section 510 prohibits benefit interference. The ADEA bans age discrimination. Courts have repeatedly ruled against employers who try to save money by cutting long-term workers before retirement. The bottom line, employers can make tough business decisions, but they cannot fire you simply to avoid paying benefits you've earned. If you face this situation, gather evidence, know your rights, and don't hesitate to file a complaint. If this video clarified your rights, share it with coworkers. Knowledge is protection, and the more workers understand these laws, the safer retirement becomes for everyone.